in the amount of $4,200.
I initially am asking for $4,200, which is the $3,600 I paid as a first installment in a conditional agreement, a two-part conditional agreement. $66 for the service cost to serve the defendant, and then 4 days worth of work I missed over the course of this incident and dealing with this. I am, however, at the end of the day, truly only seeking my deposit back, my deposit in the court fees. And this is something I did relay.
Okay. So tell me what happened here. Again, you wouldn't be entitled to the lost work anyway. So $3,600, where are we at? What happened?
So, Your Honor, this action arises from the defendant's breach of a two-part agreement for an RV that she had listed on Facebook Marketplace. The defendant's misrepresentation regarding the RV's condition and legal ownership, and her refusal to return a $3,600 deposit after the transaction failed due to the RV being unsafe, non-roadworthy, and incapable of lawful transfer. This matter concerns a clear breach of contract and bad faith conduct by the defendant, and it has resulted in financial harm to myself, the plaintiff.
So what happened? Did you?
So I contacted the defendant in hopes to purchase her RV. I had been looking for housing. I was getting very close to, my housing issue was running out, and I was getting very close to homelessness. I initially asked her right off the bat if she would take a lower amount. She had her RV listed at $4,500. I asked her if she would take $3,600, and she did immediately say yes. She did say she was looking to get closer to $4,000. And me being in the position that I was in, which was an incredibly, incredibly bad, very strained situation, wanted to also try to help an individual out as well. I was asking if she would be willing to do something a bit unorthodox where we could do a two-part arrangement. And I wanted to specifically do this so that I could have time to check over whatever vehicle, whether it was her or anyone else, that I could check over the vehicle and make sure it was safe. As the vehicle in question, whichever it was that I was going to be purchasing, was going to be my residence, not only my residence, but my transportation. So this was going to have to last me years. It needed to be safe. It needed to be reliable. These were my main concerns. I took it to have it diagnosed. It came back less than 24 hours later with over $7,000 worth of damage, major mechanical failures that the defendant did not remotely allude to. She continued to double down that the vehicle was safe, even after a diagnostic report conclusively shows that it's not safe to drive. The shop also highly recommended that it is not driven, that it was not safe. So I then told the defendant that she had to move it at her own expense because I was not going to risk my safety. I then immediately demanded the return of my deposit because I was no longer going to continue on with the agreement, as the basis for why I entered the agreement with her and what she represented was not factual nor true, therefore nullified our agreement. She then told me that she was unable to do that because she spent the money on several big bills she already had and was unable to return the deposit money. I then told her that that didn't negate her from needing to return the deposit money, especially since the deal was not complete. Our deal was going to be complete on Friday when I gave her the remaining balance of our second part of our deal, where she would then transfer over the title. At that point, our deal would be complete. So at the time that she spent the deposit money, I was not in legal possession of the vehicle. I did not have the title. It was not in my name. And she still retains that. So she has
just a second. Stop for a second. I have a question. So where is it now? Where's the RV now?
She has the RV. She has it.
And the title's in her name?
Correct.
Still?
The title's in her name, which she transferred into her name after we entered this agreement. So at the time we entered this agreement, she was not the legal owner of this RV.
Got it. Ms. Sager, what's your position on all of this?
Ms. Lapel was interested in purchasing my RV. Like she said, I would have it listed for $4,500, and she asked if I would take 36, and I said I said I'm hoping to get 4,000. You can see that in our messages.
I did see that.
Yes, and she said, I only have 36 now, but I'd be willing to meet you at 4,000 if you can wait until I get my next paycheck on Friday, as she just stated that she would have the remaining 400 on Friday. I said that was okay, and I said I'd like to hold on to the title until you're able to give me the remaining $400. Your Honor, the first I heard of this being a deposit contingent on a mechanical review was after she was already asking to give the RV back and get her money back. As you can see in our handwritten purchase agreement, which I submitted and she also submitted, it's Exhibit 1 in my table of contents, and it's the last page 69 of her evidence. There's nothing listed or mentioned about $3,600 as a deposit, which is a very large amount for a deposit on a $4,000 purchase. That's an odd amount to give as a deposit. But it doesn't mention anything about this money's being held as a deposit contingent on mechanical review.
Did you own the, she's telling me that at the time she gave you that, that wasn't even in your name. Is that accurate?
I did own it. I have a purchase agreement that shows that that it was mine a year before. I'm going through a very awful divorce, and everything that we own, everything that we own was being held in a different place. And so the reason it shows it being titled in my name only a few days after our purchase agreement is because when titles in Washington State are issued, they're a Bob and Joe or Bob or Joe. And if it's Bob and Joe, both people have to legally sign and participate in the sale. If it's Bob or Joe on the title, only one person has to be there to facilitate the sale. So I had to transfer it out of Bob and Joe from my marriage
to your separate property.
Yes,
No,
that's why the title shows a new title in my name 3 days after the purchase, her and I purchase agreement. It wasn't that it wasn't mine to sell. I had to transfer it so that through our legal process and our divorce, it showed it was coming just from me.
And you have the RV still in your name and possession?
No, sir. I gave the RV away. I held on to it and repeatedly. There's a family here in Olympia, Washington. I guess we're both in Olympia. There's a family here that didn't have housing, and I had given it to them for the winter. In October, from August through October, when our last court date was, I repeatedly offered it back to Destiny. It's in great shape. It's beautiful in the inside. It's completely livable. I can walk you through the inspection.
Okay, so hang on just a minute. You know, one thing that I should have done but didn't do, and that is don't interrupt the other party. She didn't interrupt you, Ms. Lapel. I'd offer her the same courtesy. You'll get an opportunity to respond.
Apologies.
But go ahead, Ms. Sager. You can continue.
Yeah, I held it for her through October when our last court date was. And at that time, I was paying storage fees for it that whole time. And I held it in the hopes that she would take it back. It's a great vehicle. If I hadn't needed the money to take care of my family myself, I would have kept it. And I held it through October, and I did let Judge Buckley know in October that, Your Honor, I won't be able to keep holding it until the end of December. I can't afford the storage fees, but I was happy and available to still let Destiny have it. I would have driven it to wherever she needed it. I would have helped her sell it to recoup the money. But I was not able to keep paying the storage fees for another. She asked for a continuance, and Judge Buckley granted that until today, and I wasn't able to hold on to it for her. And so it was not a deposit. As you can see in our contract, it was for the amount of $4,000, as is, 36 paid in cash on the 3rd, 400 to be paid by Friday, to be paid by that Friday when she said she got her one of the tire, the air was low, and I recommended she bring it to Busy Bee Automotive, which was down the road from my house. She test drove it for almost an hour. I would like to say that as well. She brought it to Busy Bee. And they asked if she wanted a full diagnostic, and she said yes. And they kept it overnight, and they did that. And in the diagnostic, what they gave her was their recommendations of work that needed to be done or could be done. So it was $7,000. As you know, mechanics do that. They'll say you should do all these things, but none of that was necessary for it to be driven, for it to be lived in. It was meticulously owned by the same couple. It was beautiful inside before I got it. Everything worked. Shower, toilets, all the beds, microwave. It had a larger stove than normal. And mechanically, there were things I let her know. It's almost a 40-year-old RV. I had let her know there are mechanical things you'll want to do. It's past its life for road tripping across the country, but I was still taking my kids on trips with it. She sent me back a message with all these things that they said had to be done for it to be safely driven. And I explained to her that I disagree with all those things needing to be done. She said there was no sway bar, which there was. She said, you can see in her messages, all these things she said, which weren't actually like, yes, the brakes needed to be replaced. Yes, there was rusting on the wheel bearings. But she said that it needed a new radiator, that it couldn't be driven. It was only leaking radiator fluid. I didn't know. The shop told me it was leaking radiator fluid because of one seal that needed to be replaced. It had just dried out. It wasn't that the whole radiator needed to be replaced like she was saying. And if you look in their diagnostic report under radiator fan and assembly, it says findings none, because they didn't find that it needed to be replaced like she was telling me. She told me she couldn't even take it on the freeway to get it home and live in because it had no sway bar, but that's not true. You can see pictures of the sway bar in the diagnostic report. So I gave her all the information that I had about the RV. She test drove it for an hour. She was really enthusiastic about having it. And I am understanding of this process enough that had this been a deposit contingent on mechanical review, as she's asserting now, I would have written that in our contract. I think that would have been in the contract, but this was a $3,600 purchase as is. She was going to pay me the remaining $400 when she got her next paycheck.
And Ms. Lapel, you had your hand up, and I know you wanted to say something. Go ahead.
Yes. You can also clearly see in the messages and the exchanges that I did say that I would give her the remaining $400 as long as everything was good. So I had a pretty bare bones requirement as far as what I needed. She is right. The inside was kept very meticulous. That was great. Whether it wasn't or not, that was not going to sway my opinion. I'm a very, very independent and mechanically inclined individual. I can repair a lot of things, as well as mechanical issues. However, these particular mechanical issues, which are major malfunctioning issues, which they did, highly recommend that it does not leave for safety reasons, which is precisely why I made sure that the defendant knew that she was going to need to move it at her expense. I would not risk my safety again. The radiator being blown requires a new radiator. So these are all recommendations, because it's a recommendation that if you want a safe vehicle, this is what you need to do. They're not going to tell you, no shop can tell you, you have to do this. It is always going to be a recommendation. This is a shop that she specifically recommended. She said, I've just recently been to them. They're new in town. They're great. Highly recommend them. I went there as soon as I responded to her and let her know what the diagnostic findings were, what the shop said. She said, I don't think that you should trust them. They're new in town. I think you should go somewhere else for a second opinion. So she instantly turned around her opinion on that. This is the most thorough diagnostic report I have ever received anywhere. I thoroughly trust these guys. They were incredibly kind. They were very transparent. They were very cooperative all the way through. They were able to get me that diagnostic report not even 24 hours later. I dropped it off with them Sunday August 3rd at 2 p.m. And they got back to me, I think it was like 11 or noon the following day. And I immediately contacted the defendant. So it wasn't even 24 hours later. And that's when she told me that she had spent that money. So regardless if she's unclear on it being a deposit, which in a two-part agreement, a first installment in a two-part payment agreement is a deposit from what I'm understanding and what I'm learning, whether it was explicitly stated as a deposit, it does also show in my messages that I, again, reiterate, as long as everything is okay, as long as this is all good, I will then at Friday give you the remaining $400, which is why I chose to not do that, which is why I chose to back out, because everything was not okay. They recommended the work that was about $7,000 worth of work that already puts me in the hole. I took out a $2,000 loan out of this $3,600 to try to buy something. So I'm already in the hole for that too. I still have to pay that $2,000 loan back. She's still in retention of my deposit and the RV. I'm not sure why the defendant feels that even if she's misunderstanding if this was a deposit or not, why she still felt that there was legal basis or right for her to spend that money before the completion of the agreement. Like until Friday, when I gave her that $400 and she handed me the title, our deal was not complete. It was still in a partial agreement. Whether she had big bills or not, that money should have been saved to be spent until after and it was finalized and completed. That does not negate her from needing to return that money when there was no exchange of goods.
There was
not. Also, I'm
So
sorry.
hang on,
I'm sorry.
Ms. Lapel, if you're done, you can stop.
I'm
and
not
then
done.
Ms.
I'm
Sager,
not, because
okay.
I do
Okay, keep
specifically
going.
remember something I wanted to respond to. And in regards to that, she brought up last court hearing that she would gladly give it back to me. She also continuously, in her giving back, she wants me to pay the remaining $400 in order to give it to me. So she's not giving it to me. She still wants me to pay for it. I'm still buying it and I don't want to buy it. Like, I don't feel like I should be coerced into buying something that is mechanically not sound, that I was not. I was very clear. I came very thorough, very, very prepared. And I may have left emotional because of an issue with my mom, but that does not mean or justify any legal basis for her spending money that was not legally hers yet to spend until a title was transferred.
So Ms. Sager, I'll give you the final word here, and then I'll be ready to rule.
I would have been, had she wanted to take it to a shop before she purchased it, that would have been just fine with me. I loved this RV. This signified like my freedom from my divorce. My kids and I traveled in it all summer. It was a great RV. I wish I could have kept it. I think she was getting a really great deal. There is nothing in the diagnostic report that shows it couldn't be driven. I drove with it all summer. She told me I was lying. I sent her a video of me driving it with my kids just a month before. She said I was lying because my hair was different, but I'm going through a divorce and my hair has been 4 different things in 1 year because that's what I have control over. It was long and platinum blonde when she bought it. It's short brown now. I drove with it with my kids and their friends to the beach and the coast and camping all summer. It was a great RV. She bought it as is. There's nothing in the diagnostic report that shows it was undrivable or unlivable. She gave me the $3,600 and would have given me the full $4,000 that day. She said had she had it, but she needed to wait for her next paycheck. I'm a single mom now with a full mortgage that I can't afford. The day I was already late. The day that she gave me the money, I immediately went and paid my mortgage and all of my bills, my water bill. I offered to give her the RV back multiple times. I offered to help her sell it, to help her recoup her cost. She could have driven it to wherever she needed to and fully lived in it or resold it. It was in amazing condition. You can see in the pictures, I kept like tire covers on it. It was, you know, besides the work in the diagnostic report that they recommend, like 2 bricks driving on and then 1 seal for the radiator. the other work that you can see, which just comes along with a 40-year-old RV. It was completely drivable and livable. And I'm really sorry this happened, but we did have a contract and we did sign it as is. And
How did the RV get from the place that was being inspected back to your place, ma'am, Ms. Zager?
I went and picked it up. She told them they told her in the messages you can see, they told her there's a fee beyond a certain number of days if you leave it here. She lives out of town, and they told me I'd be responsible for that daily fee if
How did we
if
get
it
back to
was
the
there.
other session?
And then she told me you need to go pick it up. And so I went and picked it up from the shop.
All right. So here's where I'm at there, ma'am. Basically what happened, as far as I can tell, you had reached to, I think this was through Facebook Marketplace, if I'm not, or one of the, and where this was listed for sale was an RV, apparently an old RV listed for around $4,000. Apparently some sort of agreement was reached, but was never completed. Ms. Lapel took the RV, which is quite reasonable, to get it inspected to find out if what the condition of the thing that she wanted to buy. Once she found that out, lost interest in the RV, decided I don't want to buy this RV anymore. It wasn't really used. It wasn't really, title was never transferred into her name. And so the deal was never completed. Basically, it was just rescinded as far as I can tell. And then, and I recognize both of you apparently are in difficult financial straits. And I'm sorry about that for both of you. But in that she never took possession other than just to get it inspected. Title was never transferred. I find that the deal was never completed.
Your Honor,
It was given to somebody else. Hang on, ma'am. Just let me finish, please. And so basically to decide in favor of you, Ms. Sager, it means that basically you would get, she's out $3,600 and gets nothing in return. And that's kind of where she's at. So I'm going to decide in favor of the plaintiff. The deal basically went off, and a judgment will enter in the amount of $3,600 plus a $50 filing fee and $66 service fee. Total judgment amount of $3,716. You wanted to say something? Go ahead. Ms. Sager, you're back. Wait a minute. I think we're waiting for Ms. Lapel to come back. There you go.
Sorry, I panicked. I didn't know what happened.
Your
Go ahead,
Honor,
Ms.
Your Honor, I would have given her the title the day we signed the contract if she had the full amount.
Right, I understand that, and it was never. I know that. That means it was never the full deal. Never completely went through.
But she
refused.
She refused to take. I offered her the RV back. She told me to go get it from the shop, and I said, "Come get it. Come get it. It's yours. You signed a deal." Like I offered to give it to her back.
I understand that, ma'am.
Signed an agreement, Your Honor, and actually, I understand the way this works. I would have given her she still owned the RV. I left it on my property for months, and and then I moved it to a storage unit. And I told her, I said, "This is your RV. Come get it." And she said, "I don't want it back. I only want my money back." But she had already bought it. She had already agreed and signed the contract. And when you buy a car from a car lot and you're making halfway payments and then you decide to stop, it's not like you just get all your money back from a lot.
Okay.
Like
so, ma'am, this isn't a lot. This is quite a lot different from that. And I've explained my ruling. If you disagree with this, you're free to appeal that. But that's going to be.
This case is one of those painfully human disputes where two people, both under real financial pressure, collide in a deal that was never properly finished. And the courtroom becomes the place where reality finally catches up. What we're watching here isn't just a contract disagreement over an old RV. It's a breakdown of expectations, assumptions, and timing, all happening while both parties are in survival mode. On one side, you have the plaintiff, Miss Lapel, who is very clear about why this RV mattered so much to her. This wasn't a luxury purchase, this wasn't a weekend toy. This was supposed to be her home and her transportation at the same time. She says she was facing housing insecurity, even homelessness. And because of that, safety and reliability weren't negotiable details, they were the entire deal. From her perspective, the agreement was always conditional. A two-part payment where the first installment bought her time to verify that the RV was actually safe to live in and drive. When the diagnostic report came back with thousands of dollars in recommended repairs and warnings about safety, she believed the foundation of the agreement collapsed. No safe vehicle meant no deal, and no deal meant her money should come back. On the other side, you have Miss Sager, who tells a very different story. To her, this was a straightforward as-is sale. The RV was old, yes, but functional. It had been driven all summer. It had been lived in. It wasn't perfect, but she never claimed it was. She saw the $3,600 not as a deposit, but as the purchase price minus the final $400 that was coming on Friday. From her point of view, the inspection didn't uncover anything catastrophic, just the kind of maintenance any 40-year-old RV is going to need. And critically, she says nothing in their written agreement made the payment contingent on inspection. To her, the buyer simply changed her mind after the fact. What makes this case especially messy is that both versions contain elements of truth. Yes, Miss Lapel did test drive the RV and took it for inspection. Yes, Miss Sager did still hold the title and retained legal ownership the entire time. Yes, the money was spent before the transaction was completed. And yes, the RV was never transferred, never titled in the buyer's name, and never fully delivered as a completed sale. The judge's role here isn't to decide who needed the money more, or whose life circumstances were more sympathetic. The court isn't a referee for hardship. It's there to answer a narrower question. Did a completed sale occur? And if not, who is legally entitled to what? And that's where this case turns. The judge zeroes in on possession and title. Two things that matter enormously in disputes like this. Miss Lapel never received the title. She never legally owned the RV. The transaction was incomplete. Taking the RV for inspection does not equal taking ownership. There was no final exchange of goods. The judge also recognises something else that's crucial. Even if both parties believe different things about whether the payment was a deposit or a purchase, the deal itself never reached the finish line. Without completion, the law generally favours unwinding the transaction and putting both parties back where they started. Miss Sager's explanation about spending the money immediately is understandable on a human level. She needed to pay her mortgage. She needed to pay bills. But legally, need does not create entitlement. Spending funds before a transaction is complete is always risky, especially when the title hasn't transferred and the buyer still has a clear opportunity to walk away. The judge also acknowledges that inspections are reasonable. Buyers are allowed to discover things they don't like. Sellers don't get to decide which problems are serious enough for a buyer to back out. What matters is whether the buyer accepted the goods and whether the seller completed delivery. Here, neither happened. This case is a textbook example of why vague agreements are dangerous, especially in private, informal sales. A single sentence clarifying non-refundable deposit or sale contingent upon mechanical inspection would have likely prevented this entire lawsuit. Instead, both parties relied on assumptions and verbal understandings, and when reality intervened, those assumptions collided. By the end, the judge makes it clear that while he sympathises with both women, sympathy doesn't override contract law. The deal was never completed. The RV stayed with the seller. The title stayed with the seller. And because of that, the money cannot simply be kept as if the sale had gone through. There are no villains here in the cartoon sense. There are just two people who were desperate, trying to solve big life problems with an informal agreement that wasn't strong enough to carry the weight placed on it. One needed housing, the other needed financial relief. The law, however, doesn't bend based on need, it bends based on completion. And the quiet lesson of this case is one the courtroom teaches again and again. If the deal isn't finished, the money isn't yours. Not yet. Not legally. And no matter how understandable the circumstances, spending it early can turn a bad situation into a losing one.